Welcome to the deep dive. Ever think about how a seemingly simple accident, the kind that happens every day, could sort of spiral into this massive legal saga that completely redefines the rules of the game for an entire country?
That sounds pretty dramatic, doesn't it?
Hmm.
But that's exactly the story of National Employers Mutual General Association, Ltd v. Waind, or NMGA v. Waind, as it's often called.
NAMGA v. Waind, right.
Yeah, it took a basic personal injury claim, an insurer's file, nothing unusual there, and somehow ended up reshaping two fundamental pillars of Australian law.
And that's our mission right now. You've brought us the source material on this really pivotal case, and we're diving deep to, unpack its drama, meet the key players, follow its incredible journey through the courts.
And understand its, frankly, surprising and lasting impact.
Yeah, we're talking about legal professional privilege, that crucial right to keep certain communications confidential.
Yeah, lawyer-client stuff, basically.
Exactly. And also the often tricky process of getting documents from someone who isn't even really involved in the main lawsuit, using what's called a subpoena.
Right, getting info from a third party. And it all starts not in some high-powered courtroom, but with, like you said, an everyday accident and the pretty routine paperwork it generated.
Okay, let's get into the setup then. Our story kicks off back on June 27, 1974. There's a Mr. Frank Waind. He was working for Goodyear Tire and Rubber Co., and he suffered some injuries. Now, the allegation was these injuries were caused by the negligent driving of another person, a Mr. Mark Gary Hill.
So just like you said, a pretty standard setup for a common law negligence claim.
Yeah.
You've got the injured person, Waind.
Pointing the finger at Hill, the driver.
Right. But because Waind was an employee injured, potentially, during work-related activities, he was also covered by workers' compensation insurance.
Ah, okay. And that's where our third major player comes in, NEMGI, the National Employers Mutual General Association, Ltd.
Quite a mouthful.
Yeah.
NMGA, yeah. They were the workers' comp insurer for Waine's employer, Goodyear.
So naturally, when a workers' compensation claim like Waine's comes in, even if there's this separate potential lawsuit against the driver, Hill the insurer and MGI, they open a file.
Standard procedure. They started their file on Mr. Waind around July 14th, 1975. And over the next year and a half or so, until about February 1977, this file just grew.
What kind of stuff went into it?
Well, the usual things an insurer would gather. Reports from investigators they hired, medical reports from doctors they sent Mr. Waind to see, all part of assessing the claim.
Okay, standard operating procedure for an insurer figuring things out.
And here's where the crucial tension starts, the seed of the whole legal battle later on. When MG was actually getting these reports, when these documents were being created and put in the file.
The investigator notes, the medical opinion.
Yeah, all of that. At that specific time, no formal legal action had actually started in the Workers' Compensation Commission about Waine's claim.
Right. So they weren't being created because NMGO was already being sued in, the workers' comp tribunal or court.
Exactly. They were part of NMGA's own internal process, their internal machinery, as the sources nicely put it. Just them trying to figure out what happened, assess their potential liability, decide how to handle the claim, manage payouts.
This creates a fascinating question, doesn't it? Were these documents just sort of routine business records for their own internal assessment and decision-making?
Or were they prepared specifically because MGA was already thinking, this might end up in court, anticipating a legal battlefield?
That blurred line, the purpose, the real reason these documents were created that became the absolute heart of the privilege fight, the explosive core.
And that explosion, well, it was lit by the next move in the story. While the workers' comp side was sort of simmering, Mr. Waine's main focus was his common law negligence lawsuit against Mr. Hill.
That was happening in the Supreme Court of New South Wales.
Right. And during the hearing for that case, Hill's legal team, they made a really significant strategic move. They issued a subpoena, deuces to cum fancy name, for a legal demand to produce documents.
Right. Bring us the papers.
Exactly.
Yeah.
But it wasn't directed at Waind, the person they were actually suing in that case. It was directed at NMGO, the insurer, a complete third party to this particular lawsuit between Waind and Hill.
And the subpoena wasn't exactly narrow, was it? It demanded all documents and the like related to Waine's workers' compensation claim. Pretty broad.
Oh yeah, casting a very wide net into the insurer's files.
What were they hoping to find?
Well, from Hill's perspective, the strategy seems pretty clear. They were fishing for anything in that insurer's file that could potentially weaken Waine's claim for damages in the negligence suit.
Like what? Maybe notes suggesting his story wasn't quite consistent.
Exactly. Or records of pre-existing conditions the insurer's doctors might have found. Maybe even, surveillance reports or evidence suggesting his injuries weren't as bad as he was claiming in the negligence case.
It was basically a calculated probe into someone else's records for potentially damaging dirt.
Pretty much. And NMG suddenly finding themselves dragged into the lawsuit between Waind and Hill. They had to respond. They turned up to court.
Okay.
They produced one file without any issue. But then they objected. They refused to hand over a second, apparently more sensitive file.
And their reason, their shield.
Legal professional privilege. They claimed the contents were confidential communications protected by law.
And this objection, this refusal over the second file, that's what turned a pretty standard procedural step, just responding to a subpoena into this, well, full-blown legal war over a fundamental legal principle.
Yeah, the fight for that file, with all those internal insurer documents, began its dramatic climb up through the court system.
Okay, so let's move to the first battlefield. Act I, the Supreme Court. The initial hearing on M&G's privilege claim took place before Justice Carmichael in the Supreme Court of New South Wales.
All right, let's set the scene a bit. Introduce the dramatis persona, the key players in this first act. Presiding, as you said, Justice Carmichael.
And the lawyers.
Representing the plaintiff, Frank Waind, we had senior counsel R.V. Giles QC, that's Queen's Counsel, a top barrister along with F.M. Douglas. They were instructed by the solicitors McClelland, Wallace, and Landa.
Okay. And for the defendant, Mark Carey Hill.
That was P.E. Coleman, instructed by the solicitor J.A. Gill.
And NMGA, the ones claiming privilege.
Well, initially their solicitor appeared, but then they brought in counsel D.I. Cassidy, instructed by the firm Hunt and Hunt. So you can already see, significant legal teams forming.
So NMGA argues to Justice Carmichael, this file, it's privilege. Why? Because the documents inside were created for the overriding purpose, they said, of anticipated litigation.
Specifically, they argued the purpose was getting ready to defend themselves if Wayne's workers' comp claim ended up in the Workers' Compensation Commission, which they expected might happen if they denied liability.
Okay, makes sense from their perspective. What evidence did they have?
Crucial evidence came from a Mr. Tritton. He was an officer who worked for NMGA. And on the stand, he initially testified, yes, the purpose of getting these reports was, quote, to decline liability and to defend the matter. Sounds good for NMGA, right?
Seems pretty clear-cut for privilege, then.
But here's where the cross-examination by Hill's counsel, Mr. Coleman, became absolutely pivotal. Under pressure, Mr. Tritton made several, pretty damaging concessions for MGA's claim.
Oh, like what?
He admitted that actually about 90% of workers' compensation claims don't end up in formal litigation. They get resolved without going to court.
90%. Okay, that undermines the litigation was definite idea.
Massively. He also clarified that the reports were used first and foremost by NMGA internally simply to decide on liability. Litigation only came later if they chose to deny the claim.
So the primary use was internal decision-making?
And perhaps the most damning point for NMGA's privilege claim. Mr. Tritton stated that these reports were, quote, never, or in 99% of the time, not actually sent to NMGA's solicitors for that initial internal decision-making. The decisions were made by NMGA's own officers using these reports.
Wow. So the lawyers weren't even involved at that crucial stage for most cases.
Exactly. So you have Hill's counsel arguing strongly against privilege, wanting access to that file. And then, in a really fascinating twist of legal strategy, Wayne's counsel, Mr. Giles QC, and Mr. Douglas, the plaintiff's team, they actually sided with MGA. They supported the privilege claim.
Wait, Wayne wanted the insurer not to hand over the documents to Hill, the guy he was suing? Why?
It seems counterintuitive at first, doesn't it? But think about it strategically. Wayne's team probably figured that insurer file likely contained information that could be harmful to their case against Hill.
Like maybe medical opinions that weren't entirely glowing or notes about inconsistencies in Wayne's own story that the insurer picked up.
Precisely. Their main goal at that moment was stopping Hill from getting his hands on potentially damaging information. It's a classic example of these shifting tactical alliances you see in complex litigation. The enemy of my enemy sort of thing.
Okay, so Justice Carmichael hears all this, the arguments, Tritton's crucial testimony, the odd alliance. What did he decide?
He delivered his verdict. He rejected MGA's privilege claim. Flat out.
Why?
He found that the documents in the file did have a purpose related to potential litigation, yes. But crucially, they also had another distinct purpose. helping MGA decide liability internally as part of their routine business operations. It was a dual purpose.
Dual purpose, okay. And why was that fatal to the privilege claim?
Because Justice Carmichael applied the very strict sole purpose test. This test had just recently been clarified by the High Court of Australia in a landmark case called Grant v. Downs in 1976.
The sole purpose test, what does that mean?
Under that test, for legal professional privilege to apply, the one and only purpose for creating the document must have been for submitting it to legal advisors, for advice, or for use in actual or anticipated legal proceedings.
Sole purpose. Not main purpose or primary purpose, but sole purpose.
Exactly. And because these documents in MGA's file clearly had that other coordinate business purpose deciding liability internally, they failed the sole purpose test. Privilege denied.
What happened immediately after that ruling? Did Hill's lawyers get the file?
No, not yet. The consequence was quite traumatic. The actual trial of Waind v. Hill was immediately halted, stopped in its tracks.
Why?
To allow NG time to appeal Justice Carmichael's decision before Hill's lawyers could get their hands on the file and actually inspect it. The cat, as they say, was not yet out of the bag. The contents of that sensitive file were still secret, but the battle for access was definitely moving up the ladder.
And so the case escalated. Act 2. We move to the Court of Appeal. The fight for the file goes up to the Supreme Court of New South Wales Court of Appeal.
Right. And presiding at this level was a pretty distinguished panel of judges. President Moffat, Justice Hutley, and Justice Glass.
And things getting a bit more complex here, didn't they? There wasn't just one appeal.
No, that's right. In a neat procedural twist, there were actually 2 separate appeals being heard together, both stemming from Justice Carmichael's original ruling down below.
Okay, break them down for us. Appeal number 1.
First, NMGDA was appealing the rejection of their privilege claim. They were still fighting tooth and nail, arguing that the file should be kept confidential based on legal professional privilege. They hadn't given up on that.
And appeal number 2.
Second, Mr. Waind himself, the plaintiff, was appealing Justice Carmichael's order that would have permitted Hill to inspect the documents, assuming they were privileged.
So Waind wasn't arguing privilege anymore, but something else.
Exactly. His argument now was purely procedural. It was about the proper use of a subpoena, especially when it's aimed at a third party like NGA. Was allowing inspection just fishing? Was it effectively allowing improper discovery against a stranger to the lawsuit? He was trying a different angle to keep the file closed.
Okay, let's check the legal teams again at this Court of Appeal level. The judges are President Moffat, Hutley J.A., and Glass J.A.
Correct.
NMGA is still the appellant on the privilege issue. Same counsel, D.I. Cassidy, instructed by Hunt and Hunt.
Yes, they retained their team.
Waind is the appellant on the procedural point. Still R.V. Giles QC and F.M. Douglas, instructed by McClellan, Wallace, and Lunda.
Still fighting to keep Hill away from the file, yes. Retained counsel.
And Mark Gary Hill is the respondent, the one defending the original decision in both appeals. Still P.E. Coleman, instructed by J.A. Gill.
That's right. The core legal teams are still locked in this battle over the file.
Okay, let's take NMGA's privilege appeal first. What happened there? Justice Glass gave the main judgment, right?
Yes. Justice Glass delivered the leading judgment on the privilege point. NMGA basically repeated their arguments from the trial.
Yeah.
That Justice Carmichael got it wrong, the overriding purpose was litigation.
But the Court of Appeal didn't buy it.
No. Justice Glass, with President Moffat and Justice Hutley agreeing, found that the evidence presented at trial, especially Mr. Triton's testimony about internal decision-making being primary, amply supported Justice Carmichael's finding that the documents had a dual purpose.
And did they address the Grant v. Downs sole purpose test?
Oh, absolutely.
Yeah.
This is where the Court of Appeal delivered a really powerful, clear restatement of that strict test. Justice Glass quoted directly from Grant v. Downs, documents must be brought into existence for the sole purpose of submission to legal advisors or for use in legal proceedings.
Sole purpose again.
And he articulated the principle with striking, almost unforgiving clarity. He said, and this is a key quote, "If the purpose is not single, but multiple, unless all of them fall within the protected group of purposes, no privilege attaches."
Wow. That leaves absolutely no wiggle room, does it?
None whatsoever. It smashed the idea that a primary or overriding litigation purpose was enough if other non-privileged purposes like internal business assessment also existed.
So because NMGA's internal business purpose of deciding liability was clearly one of the purposes, and that's not a legally protected purpose,
their privilege claim failed again. Justice Glass dismissed NMGA's appeal, ordered them to pay Hill's costs for that appeal.
What was the impact of that part of the judgment?
It powerfully hammered home just how strict the sole purpose test was in that era. It sent a really clear, unambiguous message, especially to insurers and large corporations. Those mixed-purpose documents, even the ones created with a strong eye towards potential litigation, were very likely not going to be privileged if a routine business function was also part of the reason for their creation.
Okay, so MGA lost on privilege again. Now, what about Waine's procedural appeal? The one about whether Hill should even be allowed to inspect the documents. This led to a landmark judgment from President Moffett, right?
Absolutely. This is the other major legacy of Waind. Waine's counsel, remember, was arguing, based on an older case called McAuliffe, that you could only subpoena documents from a third party like MGA to compel them to bring the documents to court so they could be immediately tendered as evidence.
Not just to have a look first.
Right. They argued that allowing Hill to just inspect them beforehand, maybe to decide if he wanted to tender them or how to use them in cross-examination, or yes, just to fish around for useful info, was an improper use of the subpoena power against a stranger. They wanted a rule saying inspection only happens if the document is clearly admissible or if the party inspecting promises to put it into evidence.
But President Moffett wasn't having it.
Not at all. He, along with the other judges, decisively rejected those arguments. He stated quite bluntly that the McAuliffe case they relied on ought not be followed. Done.
And then he laid out something new.
Yes, this is where he articulated what has become the seminal three-step procedure that still pretty much governs how courts in Australia handle documents subpoenaed from third parties today. It brought real clarity.
Okay, what are the 3 steps? Step 1.
Step 1. Obedience to the subpoena. The person or company getting the subpoena brings the documents to the court. They hand them over, not to the party who issued the subpoena, but to the judge. And at this stage, the document holder, NMGA in this case, can raise any objections they have, like the subpoena is too broad, it's oppressive, it's unduly burdensome, or of course they can claim privilege over some or all of the documents.
Okay, documents are physically in court, under the judge's control. Step 2.
Step 2. Judicial decision on preliminary use and inspection. Now the judge has the documents. The judge decides whether to allow the parties to the lawsuit Waind and Hill to inspect those documents.
On what basis does the judge decide?
Based on their apparent relevance to the issues in the main case. It's a discretionary call for the judge. It's not about formal admissibility yet, just whether they look like they might be relevant, whether seeing them could help figure out the truth of the dispute between Waind and Hill. The judge balances the need for information against the burden on the third party.
Got it. Apparent relevance checked by the judge. Then step 3.
Step 3. Admission into evidence or use in proceedings. This happens later, during the actual trial. After inspection, if the judge allowed it in step 2, a party say, Hill might decide they want to formally use one of NMGA's documents.
Right. Show it to the jury or use it to question a witness.
Exactly. At this point, the judge makes a formal ruling on whether that specific document can be admitted into evidence according to the proper rules of evidence, or used in other ways like cross-examination. This is where formal relevance and admissibility standards kick in.
So inspection is separate from actual admission into evidence.
Crucially separate. President Moffett clarified that issuing a subpoena isn't automatically an abuse just because the person issuing it doesn't know exactly what's in the documents unless it's clearly just oppressive or a pure fishing expedition with no plausible link to the case issues. The judge's role in step 2 is key. They act as a gatekeeper.
Making sure the process helps find the truth without being unfair.
Precisely. Using their discretion to ensure documents can aid a proper decision of the issues by facilitating the elucidation of the truth.
And what did Moffett P. say about Waine's attempt as a party to stop Hill, the other party, from inspecting NMGA's, the stranger's, documents?
This was another critical point. He stated that generally, a party to the litigation like Waind has no right to object just because the judge decides to allow the other party, Hill, to inspect documents belonging to a stranger like NMGA, assuming privilege hasn't been upheld.
So the main right to object to inspection lies with
the document owner themselves, NMGA in this case. They can argue about burden, relevance, privilege. But Waind couldn't really stop Hill from looking if NMGA's objections failed, and the judge thought inspection based on apparent relevance was appropriate.
So Waine's procedural appeal failed too?
Yes, dismissed with costs, just like NMGA's privilege appeal. This judgment provided really much-needed structure and clarity. a predictable framework for judges, lawyers, and third parties caught up in litigation. It balanced access to information with protecting non-parties, a huge contribution.
The Court of Appeal had spoken clearly on both privilege, sticking to sole purpose, and procedure, laying out the 3 steps. But NEMGIA still wasn't ready to give up on keeping that file secret, were they?
No, they weren't. This takes us to the final act.
Act 3, the High Court of Australia.
Having lost twice now on the privilege question at trial and in the Court of Appeal, NEMGIA sought and was granted special leave to appeal to the highest court in the land, their last stand.
And it's really important to stress, again, this appeal to the High Court was only about the legal professional privilege issue.
Absolute critical point. The Court of Appeal's clear 3-step framework for handling subpoena documents laid out by President Moffat. That was not challenged in the High Court. It stood. That part of the Waind legacy was already locked in.
So NMGA was making one final push just to keep that specific file confidential based on privilege.
That was it, their final battle. And the case was heard by the full bench, the most eminent judges in the country at the time. Chief Justice Barwick and Justices Stephen, Mason, Jacobson, Aiken.
Let's quickly check the legal teams before the High Court. Big guns time.
Definitely. Presiding, as we said, Barwick C.J., Stephen J., Mason J., Jacobs J., Aiken J. For the appellant, NEMGAA, they brought in senior counsel D.A. Hunt QC to lead D.I. Cassidy. Still instructed by Hunt & Hunt, adding a QC shows the seriousness.
Okay. And the respondents, Waind first.
For the first respondent, Frank Waind, there was new counsel. H.N. Kelly, still instructed by McClellan, Wallace, and Landa.
And for the second respondent, Mark Gary Hill.
His legal team saw a significant change, too. Leading counsel was now M.H. McHugh QC, who, fascinatingly, would later become a High Court justice himself, along with H.J. Mader, still instructed by J.A. Gill's firm. The seniority of counsel definitely reflects the importance of the principles at stake.
So NEMGA gets to the High Court. What was their argument this time? Same old, same old?
Pretty much, yes. In their final attempt, they reiterated their core points. They pushed hard again on the idea of a single, overriding litigation purpose. They argued, perhaps hopefully, for a special, maybe more lenient category for insurers, given that dealing with claims and potential litigation is their core business.
A sort of insurers are different argument.
Yeah, and they tried again to argue that even if there was a dual purpose, it should somehow be treated as one single protected purpose if litigation was a major component. Essentially, they were asking the High Court to please soften or find some kind of exception to that really strict sole purpose test from Grant v. Downs.
And the High Court's response, was it sympathetic?
Not in the slightest. The verdict was unanimous and decisive. Appeal dismissed, with costs awarded against MGA again.
Ouch! Who gave the main judgment?
Justice Mason delivered the leading judgment, and all the other judges agreed with him. He emphatically, and you could say for the final time in this particular legal era, reaffirmed the strict Grant v. Downs sole purpose test. No softening, no exceptions.
Did they accept the lower court's finding about dual purpose?
Absolutely. They upheld the factual finding made way back by Justice Carmichael at the trial, which the Court of Appeal had already affirmed that the documents in MGS file had that clear dual purpose.
Oh, mind us.
Primarily, they were created for internal business decision-making, assessing the claim, deciding liability. Secondarily, sure, they might potentially be used for litigation if liability was denied down the track.
And they relied on Mr. Trayton's evidence again?
Heavily. The High Court pointed to his testimony about the low actual litigation rate, the fact that reports were used internally before solicitors typically got involved. That evidence was just fatal to the sole purpose was litigation argument.
What about the insurers or different plea?
Justice Mason explicitly rejected MGA's argument for a special category for insurers. The rules applied to them just like anyone else.
And the idea of treating a dual purpose as one protected purpose.
Justice Mason stated very clearly that MGA's argument on that point runs headlong into Grant v. Downs. Can't argue with that. He explicitly endorsed Justice Glass's crystal clear, strict formulation of the test from the Court of Appeal judgment. No compromise.
Any other key points from the High Court?
Justice Mason also took a moment to clarify something important. Legal professional privilege protects documents based on the purpose of the document's creation, the reason it came into existence in the first place. It's not just about the purpose for which you might have obtained the underlying information in the document. It's about why the document itself was made. And Justice Aiken, in his concurring judgment, just put it very simply, based on the facts found by the trial judge, the sole purpose test cannot be satisfied. End of story.
So what does this final High Court decision really mean in the grand scheme of things?
It means that Waind absolutely cemented the sole purpose test as the strict governing standard for legal professional privilege in Australia for its time. Even if you strongly suspected you're heading to court, if the document was also created for another significant non-legal purpose, like routine business decision-making, internal assessment, managing claims it wasn't privileged, that legal purpose had to be the sole, the exclusive reason for its creation.
What an incredible journey. From a worker's accident, a standard insurer's file,
All the way through 3 levels of courts, fighting over confidentiality and procedure. It really was a crucible, wasn't it? Forging and refining these fundamental legal principles. The Waind case left an absolutely undeniable, lasting mark on Australian legal practice.
It certainly did. Let's really dig into that legacy now. Starting with that strict sole purpose test for privilege, Waind is maybe the perfect example, the high watermark, showing just how incredibly demanding the Grant v. Downs test was.
Totally. If any significant purpose for creating a document wasn't about getting legal advice or preparing for litigation, bang, you lost privilege. Simple as that under the Waind interpretation.
What did that mean practically for, say, big companies or insurers back then?
Well, it had massive implications at that time. It forced a major rethink about how documents were created, how internal investigations were documented, how claims were handled, and crucially, when lawyers needed to be brought into the loop if keeping things confidential was really important.
Because those common mixed-purpose documents.
Exactly. Things like internal incident reports, preliminary claim assessments, communications discussing both business strategy and potential legal risks, they became incredibly vulnerable if you wanted to claim privilege over them later. If a business purpose was also present, you were likely out of luck on the privilege front.
However, and this is really key to understanding Waind's place in legal history, isn't it? The law didn't just stop there.
No, the common law evolves. You could argue that the sheer strictness illustrated so clearly in cases like Waind actually contributed to the High Court, eventually revisiting the test years later.
In the Esso case.
That's the one. Esso Australia Resources Ltd v. Commissioner of Taxation in 1999. The High Court changed the test from sole purpose to the dominant purpose test.
Dominant purpose, meaning?
Meaning privilege now applies if the ruling, the most influential purpose for creating the document was a privileged legal purpose, even if other secondary purposes existed. It's a less strict test, and it's also now reflected in uniform evidence legislation across Australia.
So, while Waind and its sole purpose ruling isn't the current law on privilege,
It's absolutely essential for understanding the era of sole purpose. It shows just how demanding that test was, and it provides vital context for why the law eventually shifted to dominant purpose. It really demonstrates the common law's ability to adapt when a rule proves perhaps too rigid or impractical in certain situations. Waind is pivotal for understanding that whole evolution.
Okay, so that's the privilege legacy strictness followed by evolution. But then there's the other huge legacy, the one from the New South Wales Court of Appeal, which seems even more enduring. President Moffat's 3-step procedure for handling subpoenaed documents from third parties.
Yes, and this is arguably just as important, if not more so, in day-to-day practice now. That clear, logical framework.
Remind us again. Step 1, obedience, bring docs to the judge.
Step 2, judge decides on inspection based on apparent relevance.
Step 3, formal admission rulings later at trial.
That structure brought much-needed order and consistency to what was previously a pretty uncertain and sometimes really contentious process. How do you get stuff from someone not involved? What are their rights? What are the parties' rights? Moffat's judgment laid it all out.
And it's still used today.
Absolutely. It provides a predictable pathway for everyone involved, the lawyers trying to get the documents, the third party who holds them and wants protection, and the judges who have to manage the whole process fairly.
It strikes that balance, doesn't it, between the need for parties in litigation to access potentially relevant evidence held by others.
And the equally important need to protect those non-parties, those strangers to the litigation, from being unfairly burdened, harassed, or subjected to overly broad fishing expeditions into their private records. That procedure remains a cornerstone of civil litigation practice across Australia.
So looking back, the Waind case really underscores the vital role courts play as sort of gatekeepers, doesn't it?
Totally. They have to manage these powerful legal tools like subpoenas to make sure the system is fair, that relevant evidence comes out efficiently to help find the truth, but also that the rights and privacy of people and companies just going about their business who aren't the main players in the fight are respected. It's a constant balancing act.
And thinking about the practical consequences flowing from both parts of Waind.
Well, for lawyers and businesses at the time, the strict privilege test meant a higher risk that a lot of their internal documents, especially those created for mixed business and potential legal reasons, could be forced out into the open in litigation. It definitely compelled companies to think much harder about their document creation protocols, their internal communication policies, their risk management strategies, especially if they hope to maintain confidentiality later.
Maybe getting lawyers involved earlier in some processes.
Potentially, yes, if privilege was a key concern. But the flip side, enabled by that clear three-step subpoena procedure from Moffett P., was a much more transparent and judicially supervised way to access relevant non-privileged information held by third parties.
It gave lawyers a clearer roadmap for how to properly seek information from outsiders.
And how third parties could properly object, and how judges would manage it. This definitely aided trial preparation, discovery, and maybe even led to earlier settlements in some cases, because parties got a clearer picture of the evidence likely available from third parties.
So there you have it, the whole story, cradle to grave almost. The case of National Employers Mutual General Association Ltd v. Waind. What kicked off as a pretty standard personal injury claim involved an insurer's quite routine file.
Traveled all the way to the High Court of Australia, and in the process ended up forging fundamental principles of legal professional privilege, defining this strict sole purpose test for a generation, and establishing the enduring, practical procedure for getting documents from third parties via subpoena.
It really is such a powerful illustration, isn't it? How the very specific facts of one single individual's case, something born out of a common type of accident and frankly mundane administrative processes inside an insurance company,
could become the lightning rod, the catalyst for such profound and lasting changes in the legal principles that govern access to information and confidentiality right across an entire country. It's quite amazing when you think about it that way.
So maybe a final thought for you, our listeners, to mull over. Just consider that. A standard accident on the road, a file sitting in an insurance office cabinet, and the legal challenge that erupted over accessing it fundamentally reshaped core parts of our evidence law and court procedure. It's a stark reminder, I think, of how the seemingly ordinary moments in resolving disputes can uncover, test, and ultimately sharpen the extraordinary complexities of the law itself.